This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast. You can't hear me?
Try that again.
Okay, I've been told to try that again. I guess that's one of those, we are experiencing technical difficulties.
Yeah, they're throwing
Please
me off
stand
here.
by. Good morning, Treasure Coast. Did they hear that this time?
Yes.
All right. Hope everybody has had a good week and is looking forward to a nice weekend. I don't know whether the weekend is supposed to be cooler or warmer, but I've enjoyed the coolness. I even had to put the heat on once.
Mm-hmm.
I thought, I have a brand new system. I better put it on once to make sure it works.
Yeah, try it out. Yeah.
First thing I did when I put it on, it's like I smelled it, knew it was working. So I posted on Facebook, I tried it, I smelled it, I knew it was working. And somebody posted back, what does heat smell like?
It smells like dust burning off the...
I wasn't sure how to answer that question.
Yeah.
Anyway.
You can smell it.
We have just finished Hanukkah. And I guess a good number of people are getting ready for Christmas. So everybody should be happy. Nobody should be calling me at the office. There should be no legal problems anywhere. Ha, ha, ha.
Yeah.
Bah humbug.
What, 'tis the season, right?
It is the season for lots of people to call and lots of serious issues to be presented.
Well, busy is good.
Busy is good. Judges still take off the end of December.
Okay.
Attorneys used to sort of really quiet down and all go away.
Yeah, because what can you do?
Not for over a decade, 2 decades. Mm-hmm. Attorneys keep on working to the end. Mm-hmm. Judges, I'll be gone from December 15th to the beginning of the year,
Yeah.
So you can't get anything done.
But be ready when I come back, right?
All right, I've been questioned on Facebook Live. Good morning, Palm Beach County. I don't know if you're technically considered Treasure Coast. I don't think you are. But good morning to you, too.
Oh, they're complaining you didn't say good morning.
My mother is complaining that I didn't say good morning, Palm Beach County. This is what happens when you have a mother who listens to your radio show. Thanks, Ma. Oh, and I have somebody else watching. A rabbi. Hello, Rabbi. Not the rabbi on Ask a Rabbi.
Okay.
A rabbi that has the same last name as
me.
me.
She's out cruising, isn't she? She's having a little fun.
Our rabbi is taking a cruise.
Yeah.
Her first vacation in God knows 3, 4, 5 years.
But we will have a recorded show for her coming up at 11.
I hope she is having the most marvelous time with her husband. She deserves it. She works so hard and does so much for so many people. Last Friday, we had a young lady who had her bat mitzvah a couple years ago, and my son helped lead the services. Tonight, we will be doing the same thing. And it's nice. It's very nice. And a lot of people have said this, to see the 2 youth up there leading the service, knowing what to do. I mean, they've been prompted.
Right.
So that the rabbi can actually go away on occasion and know that a service is still going to occur properly.
That's great.
So,
and you also know that they've been paying attention.
Yes, and what you also know is that this happens a lot. A lot of people will get bar mitzvah, and you never really see them again, which is, I understand, but it's also unfortunate. We happen to have the 3 who have been bar mitzvah in our temple so far. They still come. They participate. They lead the service. They read Torah. It's nice to see that they keep coming back, because the truth is, whether you're Jewish or you're Catholic or you're Muslim or you're anything else, it's the youth who are going to move on and improve the world, hopefully, change it in many respects, get into Congress and actually do something. It's the youth everywhere. And,
Looking back, has Congress ever done anything for like the past 10 years?
Oh, the past 10 years, I don't know. I do remember when I was younger and
Yeah.
I started studying political science.
They actually were doing their job.
Congress functioned.
Yeah.
As a matter of fact, I remember in high school, but, we started detouring in the beginning of the show. I always do that. I guess it's my mark. Back in high school, there was a study as to the most respected professions in the country.
Mm-hmm. Oh, I bet that list has really changed.
President was number 1.
Sure, everybody, yeah.
Congress and lawyers battled for number 2 and 3. Oh, my goodness.
Yeah.
There was another study, it may have been less than a decade ago. It's not recently, but less than a decade ago. And President, Congress, and lawyers were right at the bottom. Really, at the bottom.
Yeah.
So we'd all gone from the top to the bottom, and that has to send a message of some sort if anybody would be listening. For lawyers, I understand that message quite clearly. Every profession every occupation has their share of bad, good, excellent,
Well, yeah, that comes down to the individual.
honest, sleazy,
Yeah.
You have a plumber who comes and will charge you $5,000 for a $2 issue.
I
or
think plumbers today make more than lawyers.
That's right. Or, I've had professionals, electrician in particular, come and I'm afraid it's going to be a $2,000, $3,000 bill. And he says, $5 part. I'm going to charge you $5 in the service call.
Mm-hmm.
And wow, I mean, what honesty.
Yeah.
In this day of the internet, that's what gets communicated wide, because that's where you get your customers.
Mm-hmm.
And if somebody's going to start saying bad stuff, that's more powerful even than the good stuff. The bad stuff scares people. The good stuff is just confirmation if somebody's interested in you.
Mm-hmm.
I tell people when they come into my office for consultations, prospective clients,
Mm-hmm.
who at the end of the consultation, we're either not sure they really need a lawyer just yet, or they're not sure they want to move forward. And, I tell them, we give them a little packet, it has a lot of my reviews from a site called avo.com. And there's like 50 reviews of me there. And I tell them whether, it's a plumber, electrician, doctor, lawyer, whatever, never look at 1 or 2 reviews and believe it.
And don't look at just those first ones.
Yeah.
Scroll down, people.
Yeah. Don't look at a few reviews and just believe it, because anybody could say anything about anybody.
Mm-hmm.
If there are a number of reviews, take a smattering of them, 6, 10, whatever, and see what they're saying. If you see similar themes reoccurring, that should give you some level of confidence.
Sure.
If you see 5 or 6 people saying about an electrician who was so honest, I thought it was going to be such a much more expensive situation, and I was really shocked. And then I think you could start and assume that when you call this guy, you have an honest electrician coming to see you.
Well, nobody really minds paying a fair value for what they're whatever work they're getting.
I don't know if that's true, but they shouldn't mind paying a fair value.
Well, some things cost what they cost.
What fair value is could be debatable. There are a lot of people that blanch at what lawyers charge. Doctors are usually insurance issues, so you hate the insurance company. Lawyers, unless it's a contingency fee type case, you're paying out of pocket. And it can get expensive very, very fast.
But it all depends on what you need done. I mean, if you're in a big bind and you need a lawyer to get you out, that's the cost of getting out of a bind.
Well, that's true. But, in my situation as a litigation, as a trial attorney, somebody who takes a case from the beginning, goes through discovery, and hopefully you never get to trial, in most cases don't. But that adds up very quickly if it's an hourly case.
Sure.
And I often have to sit down with people and, say, is what you are seeking to accomplish, A, worth it, and B, the amount you're going to pay to accomplish it, at the end, are you going to be happy with the recovery if you even get it?
Right.
Unless there's an attorney's fees provision somewhere. In which case, hey, let's go. Let's
Yep.
go off to the races.
Yes.
But I've had clients who were very unhappy with modest fees. And I've had clients who didn't blink at very, very large fees, and not because they were rich, but because they respected the job that was being done. And, as a lawyer, I appreciate that, because whether the client is right or the client is wrong, when they call to question your bill, it's uncomfortable. Not uncomfortable because they're questioning you. I encourage my clients to do that. It's uncomfortable if they think that something is amiss, and you have to reassure them. My bills detail everything down to a single phone call. And actually, lawyers are encouraged to do that. The day of bills that say, for services rendered October 2017, $5,732, those days have long passed. Those bills will not pass the Florida bar.
You'd have to be really busy that day, right?
Yeah.
Very busy that day.
Those bills will not be satisfactory to the Florida bar.
Okay.
Or most bars. But that's the way it used to be. Even corporations now, they want detailed bills. So, they can support audits and all that kind of stuff. But all right, so what were we really going to talk about beyond, the end of Hanukkah and the beginning of Christmas, and 'tis the season to be happy, jolly, and
hire a lawyer.
Well, if it was the Flintstones era, I'd say gay. That has a different meaning. But I do want to say one thing before we talk about our topic. This past weekend, the Lincoln Park Academy went to their second speech and debate tournament.
Okay.
And this time, instead of having 2 competitors, we had 6.
Wow.
So
they must have liked that first one.
Yes, the others that went as observers all wanted to participate. And so we had 2 in their second tournament and 4 in their first tournament. And they were even participating in different events now. We had a number of them, including my son, in what's called oral interpretation, which is alternating rounds of prose and poetry on a similar theme. And then we had a young lady do what's called declamation, which I did way back in high school or college. And that is delivering a speech that somebody else has delivered that is of some importance.
Okay.
And doing it in a way that doesn't mimic the way they did it.
They deliver it in their own style.
But interprets it
and
sends the message. And we had a young lady of quiet voice, delivering a commencement address that an admiral recently gave to a group of Navy SEALs on their graduation.
Okay.
About the importance of making their bed in the morning and accomplishing the first task of the day, and then going through SEAL training. And I remember practicing and working with her to get her into what I called a command voice. And she did very well. One of the problems is memorizing a speech like that, because that's one where you don't go in with a manuscript, you go in with your memory.
Okay.
And for the first tournament, that's very hard for anybody when they don't really realize what it takes to truly
memorize
memorize
you're a little
speech.
nervous.
Yes.
Yeah.
And she did very well. We were very proud of her. We had great judges' comments on our ballots. And then we had a young man who I think I may have mentioned before, who is larger than I am physically, and I'm pretty large, and always spoke like this. You could barely hear him. Even his English teacher said she had never heard him all year speak above almost a whisper of a voice. So he wanted to do humorous interpretation.
Okay.
Oh boy, I thought, how are we going to prepare this gentleman to speak? So we helped him pick a piece. He picked a piece from Kevin Hart.
Okay. Very topical.
Yes, about taking your kids horseback riding. So if y'all can look it up on YouTube, I'm sure you'll find it. We had to take out the expletive, of
right,
course.
of course. Clean it up.
And the very first time when we're trying to decide whether he's going to do this, I called him up to the front of the classroom where, we're practicing. And I said, okay, here's one line from it. Deliver the line to the class. And I'm waiting, expecting it to come out
in a whisper.
And he takes a lot of deep breaths. You can tell there's nerves going on there. And then he delivers the line with a voice that nobody could ever have imagined was within him. We were all laughing hysterically from his very first line. And we fed him more lines. And we're laughing. And a week later, he has more of it memorized, and he's delivering it, and we're laughing. And it's becoming a catchphrase for the team. It's like there's one part in the routine where this trainer who's training these people to horseback riding and doesn't really speak English goes, okay, 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 let's ride. And he would deliver that much better than I just did. At 14, much better than I just did. And we were laughing hysterically. And so when his ballots came back on Saturday, and we're reading them in the van to everybody, one of the judges wrote that he almost could not write comments on the ballot because he was laughing so hard during the entire presentation. And I said to him, what better judge's comment could you have that he almost couldn't do any writing because he was laughing so hard? That was wonderful. So, I mean, I think, one of the things you want to do is build up the confidence of these kids. I've never done this before and are going up against a lot of seasoned competitors. And not just to build up their confidence for speech and debate, but to build up their confidence to speak publicly.
For the rest of their life.
Talk their mind, to present an argument logically and counter-argue logically, unlike what occurs now on MSNBC, CNN, and Fox. To really be able to deal with the points that are being raised by the other side and not just yell them down as loud as you can. And already I see such changes, such amazing changes. And our kids have all selected such serious topics: depression, police brutality, shooting of young black men, mother who loses a kid to bullying. I mean, deep topics that are important they're presenting. And I keep telling them, from my own personal experience, your goal in these types of rounds is to not just have a judge hear you, but to reach right in and grab that judge's heart. Because if you can grab that heart, you're going to place very high. You get that judge to shed a single tear, you're gonna place high. And they all have such serious, deep topics that they pick by themselves. So I'm proud of all of them. We have a meeting today after school. Looking forward. My mother's saying, now get to your topic. This is my topic. These may be future lawyers, or doctors with a good bedside manner. Who knows? Sometimes that is my topic. And we also, the last thing I'll say about this, and first of all, there's an article in TC Palm. Anybody wants to see an article about the second tournament, go to TC Palm. Just put in search terms, Lincoln Park Academy and speech. You'll get it. Great article about their second tournament with pictures. But anyway, the last thing is we had one young lady who had not participated before, who, to be delicate, let's just say her nerves were so extraordinarily extreme that we had to open the van door very quickly to get her out. And she spent most of the time before the first round in the ladies' room. Almost didn't make the first round.
A little too nervous.
Oh, yes. Oh, yes. Oh, the nerves were beyond what one would expect.
I would say she's got to get up there.
So she did make her first round.
Okay.
She came in next to last.
Okay.
But
her hurdle that she got over
right.
was.
And if that was it, that would have been enough, right?
Mm-hmm.
That would have been enough, as they say. But then when we saw her ballots at the end, the other coach and I, the English teacher and I,
Mm-hmm.
2, 2, and 1. 1. First place in a round. The first place of Lincoln Park Academy this year.
Really?
From her. And
that had to boost her confidence.
Oh, man, I'm still talking to her to make her proud.
Mm-hmm.
Because when I looked at all the results, and I did my little mathematical work, if you threw out that first round, which clearly was nerves, for everybody, if you threw out everybody's first round, she would have won a trophy.
Wow.
In her first tournament. With a 2, 2, and a 1, she would have been in the top 5.
Mm-hmm.
So we're all looking forward to the January tournament and the February tournament and state qualifiers and state championships.
They're gearing up now.
Yes.
You know that the next time they're going to be much better than they were the first
Not only
two
are
times.
we going to have one tournament a month now, they've all agreed. We just joined another league. We joined the Florida Forensic League. So now for February and April, we have 2 tournaments in the month. And they're all willing to do it, so that's wonderful. Anyway, okay. Time to get to my topic. My topic's not that exciting compared to this. I like this stuff. We've been talking about disability discrimination.
Mm-hmm.
You were out last week, but we still have never quite finished it because people, you need to call 340-1590, 340-1590. You gotta come on, talk to me, ask me questions, on anything. Call and ask me about my speech and debate team. I don't care. But anyway, we've been talking about disability discrimination, and where we sort of left off was with what if you need to take time off? Is that a reasonable accommodation that an employer has to give you? And as with most things in law, the answer was maybe. Generally, time off is considered a reasonable accommodation as long as it does not cause undue hardship to the employer.
Sure.
That depends upon what you do, what the employer does, how many employees there are, who's available to slide into your spot. Is the employer going to have to hire somebody brand new? And, then what do they expect to fire them when you come back? No, that's not reasonable. So it's very fact determinative. So the next part of where we left off really was, well, what if you have an issue, whether it's an illness or there's an accident or you have a chronic condition, and you need a modified work assignment? Can you request a reasonable accommodation? Well, the answer is certainly yes. And there are all sorts of modified work assignments. You can ask for a modified schedule. Come in late, leave early, have an extra long lunch, have extra long breaks. Those are all types of reasonable accommodations that could be requested. Now, whether they are then reasonable depends upon this interactive process that the employer and you have to engage in by law to make sure that what you're asking for, A, doesn't cause undue hardship, and B, there isn't some other form of accommodation, perhaps that the employer prefers, that is also reasonable.
Sure. And I would think that their version would be the more important version.
Well, yes.
Because it's their company.
Yes. If the employer has a different accommodation than what you suggested, but it is also legally a reasonable accommodation, then the employer gets to pick the accommodation, not you. But if you're entitled to a reasonable accommodation, you're entitled to a reasonable accommodation, not necessarily the one you asked for. So, like I said, coming in late, breaks, allowing an employee to use accrued paid leave, take time off. Those are all types of things that can be allowed. You can even ask for a part-time schedule if you're a full-time employee. Is that reasonable? Again, we have to look at the facts, and that is why when we have people that call our office on these types of things, or I suspect when they call anybody else's office, the initial screening is a fact-intensive conversation, typically with a paralegal who understands the better they are. And Cheryl's pretty good now. She's been with me for about 4 years, I think over 4 years. Thank you, Cheryl. Hard to stay with me sometimes. So people say, it's a fact-intensive inquiry as to, okay, tell me what your situation is. What do you want them to do? Have you made the request? What's the response? Have they offered something? Why wouldn't that work for you? Why isn't that reasonable? And it goes on, for a period of time until, Cheryl or whoever is paralegal A or paralegal B in some law firm, says, okay, well, let me talk to the attorney and we'll get back to you. And routinely what would happen is a few times a day, Cheryl will come into my office and we'll sit down and say she has some, we call them PNCs, potential new clients.
Okay.
So she'll say, I have some PNCs to talk to you about. Okay. And I don't even get names at that point. I get facts.
Sure.
She gives me fact patterns. And I'll ask her questions. And, hopefully she's asked that question and she'll give me the answer. And if she hasn't, if it's important, she may have to call back and get the information. But we'll go back and forth, and I will, in the end, either say, it's clear to me that they don't have a case, or it's clear to me they really do have a case, or
We need more information to find
need
out if
some
they have
more
a case.
information. And sometimes that more information is better than obtained by asking them to come into the office, not by phone. Depends on what it is. And that is how, with any case really, but when you're dealing with disability accommodations or any discrimination type case, these factual inquiries are so important because the cases are so dependent upon them. And so, yes, part-time schedule could be a very reasonable accommodation. But if it turns out you're dealing with a really small employer and it's going to create an immense hardship, it may not be reasonable. And not every employer will agree correctly, legally. Not every lawyer will agree. And that is why it's become my habit, if I tell somebody or if I have Cheryl tell somebody that, we don't see either a case or a strong enough case, what follows is, but we recommend you talk to at least one or two other attorneys because they may disagree. And you know something? They may be right. Or they may be willing to take a larger risk than I'm willing to take in terms of taking on a possibly contingency fee case. One never knows. When I talk to people and they ask me their prospects for success, and I say it's really hard to estimate. And, my fear of estimating, every lawyer's fear is, if I'm wrong, then you're going to try to claim, that I was ineffective. And I think, do you ask a doctor what the prospect for success is of a surgery? They're never going to tell you. You're going to make it through it. They're going to say, 98%, 99%, 99.8%. They're never going to say for sure that even a simple procedure.
But how can they?
They can't.
Yeah.
So not every mistake, forget the word mistake. I'm a lawyer. Strike that word. Not every adverse event that occurs medically is a doctor's fault. I understand the desire to feel that way, especially if you've really been harmed.
Right.
But not every adverse event is the doctor's fault. And the same thing with the lawyers. So when people ask me, I'll give them the standard for a litigator. Well, I think with the information I know right now, and that information is going to change with discovery, it's going to change constantly. But with the information I know right now, if I were to try this case 10 times in front of different juries, because you can't know exactly what you're going to get on a jury, I'd like to believe for me to take a contingency case that I think I'm going to win 8 out of 10 times. Otherwise, I don't want to take the risk. Now, might another attorney be willing to take it 6 out of 10 times? Sure. So you don't give up just because one attorney, whether it's me or somebody else, tells you, I don't think you have a case. I would never tell somebody to give up. You always get a second or a third opinion. It doesn't do you any harm, and it may do you a lot of good. And sometimes people call me. I'm the second or third opinion, or the fourth or fifth or sixth. And other attorneys just didn't see something, or other attorneys didn't call them back, which happens so often. And I see a case. So it works both ways. All right, so now, what if the requested accommodation violates a workplace policy? You got this lovely employee handbook with all these wonderful policies that a lawyer has carefully created. Discrimination policies, sexual harassment policies, injury on the job, all these wonderful things to protect the employer. Wonderful, beautiful handbook. Best handbook in the world, let's say. And let's say it's even fair, not one-sided for the employer. Let's say it's a fair handbook. But you need an accommodation and it violates a policy like having a 2-hour lunch. Can you request an accommodation? Can it be a reasonable accommodation to violate a workplace policy? Yes, of course. It's not like the employer is violating the policy just to violate the policy.
Right, because the policy is the general rule.
Exactly.
You are one person with an issue that we're trying to resolve.
Right, a legitimate issue. And so that is what you're requesting, a reasonable accommodation. And so, yes, An employer who comes back to you and says, I can't do that
It's in the book.
because it's in the book, it violates the policy. Oh, no, call a lawyer. Call a lawyer.
Mm-hmm.
That's an answer. That's either an uneducated answer or an evasive answer.
Or I don't want to deal with it.
Right, or a BS answer.
Yeah, I just don't want to deal with it.
No. It violates a workplace policy. That's like, let's cover myself. No. You can violate a workplace policy as long as what? Can everybody say it with me? As long as the accommodation requested is reasonable. And, part 2, it doesn't create an undue hardship on the employer. And I do believe we do have a question, which I am happy to take as soon as I get the slip of paper.
I'm holding it back for
All
a
right.
reason.
Oh, my goodness. Oh, the person who's calling, I think I'm going to be having an hour conversation with him next week on the telephone. So right now will be a couple minutes. Hello, Bulldog. How are you?
How's it going, Stuart?
It's going fine.
Good. I have a question on that because it is relevant in many ways to myself and other people. And when you say because of disabilities, but they have to be, basically something that the employer can put up with. Now, if that requires, let's say, selective hours, and that person has to really, on those hours that, or breaks or anything that they're taking off, has to be available based on their job duties as stated in their contracts, then that's not reasonable accommodations. They can't do it, and you're gone.
You had me at the beginning, but you lost me at the end. So let's do this again in the beginning. Break it down. The first part of what you said was,
okay, there are job responsibilities that you are hired on in a contract.
Okay.
That say that you need to attend these meetings, be available these hours, and everything else.
All right.
All right, and that does not include break time when you're supposed to be in meeting A or meeting B, or you're supposed to be working this drill press or something like that.
Okay.
So the company comes back and says they cannot perform the duties of their job as stated by the contract, and that's all there is, she wrote.
All right. Well, not exactly, of course.
Could you say that it makes the contract void because you can no longer hold up to it?
No. We're getting into another legal doctrine, which I'll mention in a second. But generally, I would say that's not necessarily true. If you can't make a meeting, then the question becomes, is there somebody who can cover it for you? Can the employer handle the situation without causing an undue hardship, which is the test? So even if it's in your contract and you can't perform all of those duties for a period of time, that doesn't necessarily make the requested accommodation unreasonable. However, what you've brought up raises another legal doctrine, whether you may know it or not, and that is the ability to perform the essential functions of your job.
Exactly, and that's where I was going.
I knew it, see? See, you thought you'd catch me, and you didn't.
Nope.
All right, so what are the essential functions of a job, folks? Every job has certain things. You have to do a whole bunch of tasks. They're not all essential. I mean, you have to do them. They're essential to get your job done, but they're not essential, as the law would define it. Like, people call all the time and say they've been sexually harassed, and I have to tell them, well, what has been done to you is really, really pretty bad. Unfortunately, the law doesn't call it sexual harassment. Or because there's 14 employees, they can do whatever they want to you. And it's illogical, but what one person might normally, using ordinary dictionary definitions and commonplace sense, think is one thing, well, sometimes the law says it's not. So here, what are essential functions of a job? Okay. If you are a telemarketer and you have no voice, well, you cannot perform the essential functions of your job. Does that mean that the employer can just fire you? No. If you're asking for a week off for your laryngitis to be cured, and there's 14 people that could slip into your spot, it's a reasonable accommodation.
And you could do something else.
Now you have
talk.
brought up another issue. This should be like what you would call it, the show where the chicken dropped and when the secret word was said, Groucho Marx.
Oh, geez, that's a long
That's
time
a
ago.
long time ago.
That's a long.
Yes.
That's a secret word.
That brings up that brings up
What's a secret word?
lawyer. That brings up another topic, and essentially, for everybody else's benefit, say it again.
You could do something other than the job that you do.
So it's reassignment.
Okay.
That is the doctrine of reassignment, which, guess what, was the very next thing I will here on my notes.
See?
Were you reading
It's a
upside
segue.
down?
That's what we call in the business a segue.
And I'm not supposed to acknowledge that, to be smooth. But, I'm not smooth. I just try to be effective. If you can be reassigned to another position without it being an undue hardship, then even if you're unable to perform the essential functions of your job, the employer must reassign you. So that if somebody else is able to slip in to your telemarketing slot in the bullpen, bulldog, where everybody, you're making 1,000 calls a minute, and you're able to go into the back office where you handle the orders that are coming in. And that's a reasonable accommodation. Mm-hmm. And when you're able to return to your job, you're entitled to return to your job.
Isn't that just sort of like being human?
Well, but the law doesn't require you to be human.
I guess so.
The law just requires you to follow the law. Human. How many calls do I get about people, not just employers, because I don't just do employment law.
Okay.
But people generally, neighbors, condo associations, board members, employers, doctors, that are not human, have not responded in a way that the average person in society, or at least 51% of them, given the big bridge that we have right now in our society, would consider to be human.
I've been on a couple of committees. Okay. What I think about committees, no one has any logical sense.
That's right. Well, they say also with Jews, and I'm a Jew, so I can say this. You got 2 Jews in the room, you got 5 opinions.
Okay, yeah.
So,
Nothing gets done,
that's
right?
That's right, yeah. So,
I thought that was a consensus.
Well, and our board, we try to operate by consensus. Sometimes it's hard.
No, that's a quorum, if you ask me.
That's right.
Quorum of Jews. Hey, Stuart, I look forward to talking to you.
All right, Bulldog, you take care. Thank you for calling.
And we're going to explore this because I have a question for you that directly involves me.
All right.
And a couple other people in other cases. So
okay.
We can go down that road and just have a nice old chat, all right?
All right, that sounds good. Talk to you soon.
Later.
Bye-bye. All right, that brings up an interesting thing, being human. And is there some violation of law maybe for not being human? Well, first of all, in the discrimination statute, Title VII of the Civil Rights Act, if you look carefully into the court opinions, the courts say something over and over and over again. Title VII is not a code of civility. It does not require employers to behave properly.
Okay.
Boorish employment practices does not violate Title VII of the Civil Rights Act. What violates Title VII of the Civil Rights Act is different forms of discrimination or retaliation. Being a jerk doesn't violate
you get a pass.
Title VII of the Civil Rights Act. As an employee, you have a tough choice.
Well, every employer knows people are going to get sick. If it's a temporary thing, you work through that. That's just being human.
Yes, but not every sickness is a disability. So if you get sick, you can still be fired. You're an at-will employee. And again, that a lot of people will say, I called in, I gave them notice, and it's the first day I've missed, and they fired me. I'm sorry.
Really?
Yeah, I'm sorry. It may be unfair, but it does not violate a law.
It should.
Maybe, then Congress should pass a law, or Florida should pass a statute. A lot of states give employees more protection than we do. Most states. give employees more protection than we do.
Okay.
Almost every state in the country right now is called an at-will employment state, which means you can be fired for no reason, a good reason, a bad reason, a fair reason, an unfair reason, a factually correct or incorrect reason. You just can't be
How
fired.
about no reason at all?
No, I said that's the first
Oh,
thing I
okay.
said. Just
Here's your
can't-
box. We just don't want you
Right.
to come.
You just can't be fired for an
Okay.
illegal reason.
Okay.
Now, that is the essence of at-will employment, and that is Florida law.
Okay, and I bet you a lot of people don't realize that.
No, they don't.
Yeah.
And that is the essence of Florida law. Florida law does not engraft anything extra onto it. Other states do. Other states say, okay, we start with that doctrine of at-will employment. But in our state, an employer cannot fire you for a reason that would violate public policy. That's unfair. So you get fired, you have a public policy argument.
Mm-hmm.
Not in Florida. Okay? Other states say that if you've been there a certain amount of time, you know, it's like you have a strike or something, or they have to go through certain procedures. Not in Florida. If you have an employee handbook, we talked about that earlier, and the handbook says we have a progressive discipline policy in this company. The first time you get an oral reprimand, the second time you get a written reprimand, and it's not until the third time that we fire you. So I get a phone call. Nothing has ever happened to me. I've been there 8 years. I've never had a problem. I got fired yesterday. Where was the oral reprimand? Where was the written reprimand? And I have to tell them what the Supreme Court of the United States has said. An employee handbook is not a contract, and the employer doesn't have to follow it. Gee, that makes no sense. I mean, come on.
Mm-hmm.
You're given a handbook. You're told to read it. You're told that you need to abide by it.
You do, but
And
we
the
don't.
employer doesn't,
Yeah.
but that's the law.
Okay.
The only thing the employer has to abide by is what is legally required by either federal or state statute. And there is no statute anywhere that says if an employer has a progressive discipline policy, they have to follow it.
So in that policy, if it said that you're entitled to 5-6 days a year, a week's vacation after a year, if those things are in the handbook,
Nope.
and you get fired because you're out one day
Tough luck.
sick,
Tough luck.
okay, it still doesn't.
I know, it sounds
okay.
horrible. Tough luck.
Yeah.
Now, what is an employee to do if that happens? Don't go into your bed and pull the covers over your head. You call a lawyer,
Okay.
because law is gray. Very little of it is black and white. And here, too, it is gray. What if you call me and you tell me this story? You're entitled to 5 days of sick time, and you were fired on the first day after you were sick, and you called in with plenty of notice.
Mm-hmm.
But one of the questions that we're going to ask you is, do you know whether the employer has treated you any differently than it treats ordinary employees? Because an employer cannot selectively apply the terms of the handbook.
Okay.
The handbook's not a contract,
Mm-hmm.
but you gotta treat employees the same. Otherwise, it's discrimination. And so if you're being treated differently than everybody else, then I'm going to start looking much more carefully as to why. Now, if the reason is your gender, your national origin, your religion, your gender, your age, a few other things, sexual orientation,
Mm-hmm.
except perhaps not in the 11th Circuit anymore, then the employer has done something wrong. Now, if the reason is, well, you were never sick, you and the employer are constantly arguing over and over, and this was just the employer, I had enough. No, then the employer didn't do anything wrong in violating, in treating you differently. Because it was sort of like the excuse, it was the straw, but it
Right,
wasn't really the reason. Okay, if I sued and we were in court, the employer would be presenting testimony that it's not really the reason I fired him or her. I was just tired of it. I couldn't take it anymore. And this was like the straw. Well, a jury could very easily come back and say, at will employment, find in favor of the employer, even though, employer, I think you're a jack, you know what, in the box. So, we do look at selective employment very carefully, particularly when it comes to age discrimination, which is not our topic for today, but, we're pretty close to the disability end, so I'll mention this about that. We've talked a little bit about age discrimination in the past. It protects everybody, but predominantly people above 40. That's considered the protected classification. So if you're 41 and you're fired and they hire a 25-year-old, okay, that does send up a red flag for me. Doesn't mean you have a case, but it sends up a red flag for me to ask you more questions. Now, did they fire you because you're making triple what they can pay that 25-year-old? And is the motive for firing you economic? If so, they did not discriminate you against you on bound of age. On the other hand, if they fired you because a new manager came in and the new manager all of a sudden is firing a whole bunch of people that are over 40 and they're bringing in all these young bucks, and that manager, is young and just wants to surround him or herself with young people, that's age discrimination.
Okay, yeah, give all my friends jobs.
That's right.
Yeah.
That's age discrimination. So we start in one place and we work our way through a whole factual scenario to try to determine, does the overall picture present a case? Because it's usually never just one thing. Sometimes it is, but usually it isn't. Even in overtime, my goodness, something really seems relatively black and white. You work 41 hours, aren't you entitled to time and a half for that extra 1 hour? Yeah, you are. So what could possibly be gray about that? Well, was there a time clock? Is it just you telling me it was 41 hours? How are the 41 hours computed? Are you including time that shouldn't have been included? I mean, those are the questions lawyers ask. That is, as we talked about last week, what law schools do across the country in training you to think like a lawyer. Lawyers, by definition, at least in the performance of their job, are pessimists and doubt everything.
But you have to, because how else will you get all
Sure.
the answers?
And how else, if I take a case and I put 500 hours in, I don't want to lose it. We have John on line 2. Hi, John. How can I help you?
Hi, I'm fine. First, I want to say you bet your life.
That's
Was
right.
the
That
name-
was the show. Thank you.
You're welcome. And if you have
That was a
two
secret
Jews,
word.
If you have two Jews in a discussion, there's 3 opinions.
Well, I think there's 5, but maybe in your temple there's 3.
I have a niece. She is 60 years old. She lost her job about a year and a half ago, living off of her savings, and now she's living off of her 401k.
Okay.
She has Crohn's disease,
Okay.
incurable, and I told her she should apply for a disability.
Okay.
She's all upset, doesn't know how to go about it. I suggested that she apply, and if she's rejected, perhaps she should get a disability lawyer to fight for her.
Okay. I would actually reverse that recommendation.
Start
Give
with
her
the lawyer.
Get the lawyer first.
Get the lawyer first, because this is what happens. I've seen it happen, or heard it happen many times.
Yeah.
You apply on your own, and it takes forever, or you get a denial, or you can't get anybody to respond to you, and you
Yeah.
call a lawyer, a lawyer that does disability law, not disability discrimination like me, but disability application for Social Security,
Yeah.
and they say, well, we're not going to touch it until you get an answer, because you've already started the process. That is a standard response from a disability attorney. On the other hand, if you go to the disability attorney up front,
Yeah.
you don't pay the attorney. They get a fee based upon what they're able to accomplish. And so if you have the attorney up front doing the application and you're not getting a timely response, the attorney has mechanisms that they'll go through to try to get this through for you, which all of a sudden you're stymied if you've done the application yourself.
And I understand this too. If you apply today and it takes a year to get it completed, and then you're approved, they go back to the day when you applied,
that
and
is
that's
right.
how you pay your lawyer.
Right.
Retroactive.
Yeah, you get
So,
retroactive.
so the lawyer gets paid from the person who's seeking the disability.
I'll be honest, I'm not even sure that is true.
Yeah.
It might be true.
Okay.
I have a good friend that I tend to refer people to, but I don't know if you get paid, the lawyer in that situation gets paid by the person, or whether or not there is a provision where the lawyer gets a certain standard fee and it's paid out of the from the government.
I don't know if you ever heard of the Click and Clack, the Tappet brothers. They were a couple of MIT graduates, but they had a auto repair business, and they had a program on through public radio every Saturday morning. They were hilarious and very knowledgeable. But their attorneys were Dewey, Cheatham, and Howe.
Yeah.
Oh, I've heard of that. I've heard of that law firm.
Yeah. What was the other one? Oh, yeah. You're going to hear from my lawyer as soon as he gets out of jail.
Right. Well, that's the best kind of lawyer, isn't it?
The best, yeah.
They have the best law libraries in prisons.
I'm going to tell you a quick story. I know you don't have minutes left.
That's right.
I drove cab for a year. This is an absolute true story. And I picked up a fellow who was in a car accident, and I took him to his doctor, and I waited. He came out. He got in the cab, and I took him to his lawyer. And when he came out of the lawyer's office, he had a neck brace and a cane. Now this was the mid to late 60s,
Right.
When everybody sued. But
I think the doctor may have missed something.
Well, when he came out of the doctor's office, he went in the way he came out the way he went in. When he came out of the lawyer's office, he was wearing a neck brace and holding a cane.
That's why I don't do personal injury law.
Yeah, well, that was called equipped to practice.
Yes, that's right.
Yeah, I told my brother, and that's exactly what he said to me. He's equipped to practice. Okay, thanks for your time.
Thank you for
and your
calling,
input.
John.
I appreciate it.
Take care.
All right.
Bye-bye.
I know.
All right. In the couple minutes I have left, let me just say one last thing about disability. Let me talk to you about the burden of proof if you ever have a contested case. You as the employee have the burden of showing that you have a disability and that you requested a reasonable accommodation. So you got to request one.
Wouldn't your doctor tell you that you can't return to work?
Well, it's not necessarily just can't return to work for a disability. I mean,
Okay.
You may be able to work, you just need extra breaks or something.
Okay.
But once you've done that, it becomes the employer's burden of proof in a courtroom to prove that the accommodation you requested was not reasonable and that there was no reasonable accommodation that could be made, which is a great difference in most cases. Because here now you have the defendant, the employer, that has a very significant burden of proof, as long as you've met your initial burden. So, that sort of concludes our little discussion about disability discrimination under the ADA, the Americans with Disabilities Act, Family Medical Leave Act, workers' compensation. If you have a problem like that, don't just sit home. Really, call a lawyer. There are lots of statutes of limitation out there. For example, in Title VII, you have to file a charge of discrimination within 300 days. Don't sit and do nothing. Too many people do, and they call us, and it's too late. So, as we wind down in our last minute, let me just say, lawyers aren't all bad. We're not all nasty. And we do like to rumble. Yes, I like Cliff's little intro there. I like rumbling. But we also like helping people. At least I do. So give us a call next week on Ask a Lawyer. And if you need to, call my office at 781-8003. And Cheryl will drop everything and talk to you. Have a wonderful weekend. Take care.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.